So, good afternoon, everybody, and welcome to July's webinar Wednesday. We made it to July, which is no mean feat, given the amount of legal changes that we've had thrust upon us over the recent months. And I love the Summer Roundup webinar because it really is an opportunity for us to take stock and reflect on some of those changes, maybe things that perhaps slipped through the net that we need to focus on, and then also to think a little bit further ahead. What should we be thinking about over the summer before we then really get started for that autumn push until the end of the year? Thrilled to be joined by Stephen Hall, partner in our immigration team, because this really is an update not just about employment law, but also about immigration. And my goodness me, Stephen has got a lot to tell us about as well. For those of you who don't know me, my name is Emma O'Connor, and I'm a partner here in our employment team and also head up our client training team as well. So if you want to get in touch, here are my contact details, and we'll be sharing those again at the end. If you don't know Dawn Clayton, if you're new to Webinar Wednesday, and I know we get lots and lots of people joining us who are new to the program, new to what we're doing here. The idea of Webinar Wednesday, it's a 45-minute overview. It's a higher level discussion about a legal, a leadership, or an HR hot topic. Dawn Clayton is a workplace specialist law firm. We are based in London in the city, in our fantastic new Chisel Street office, and in the Thames Valley and also in Bristol. And we support clients across the UK, Europe, and globally as well with all things workplace related, from employing, from inward investment to immigration concerns, to HR advice, litigation, as well as other services you would expect from a law firm, corporate, commercial, data protection, pensions, as well as employee ownership trusts. So if you want to find out more about what we do, why we're different, and who we do it for, then please do get in touch. Dates for the diary. Lots of things happening, lots of things that I'm running in the autumn, and it'd be great to have you and your managers signed up, either coming along to a public open course or again running these courses in-house for you. Tackling Tough Workplace Conversations, really, really popular course. I ran it back in the spring and wanting to run it again because it was just so popular. And I think a lot of the conversations that we're talking about, those employment law changes, those immigration changes, are going to involve having those difficult workplace conversations. And what do I hear most from my HR leadership contacts? Emma, how do we get our managers to have these conversations? Well, here you go. Here's a training course to help you. So do book on. Running this with an external consultant, it's really, really good. So again, if you want to book on, we'll be sending out links for that. Also, how do we master probation? Again, it's one of those HR hot topics, isn't it? When we think about the changes that are coming through in terms of unfair dismissal and the qualifying period of service. And please, please, please remember, 6 months qualifying period of service is not the same as a 6-month probation period. Okay, so we're going to have to sort of really be thinking about those probation periods. So join me running a training course suitable for business managers and for HR leads as well. Also running this course in-house, bespoke for clients. So it's a real opportunity to think about probation. How can we manage it more effectively? Again, thinking about legal risk with always an eye on what those changes are going to mean from the 1st of January of this year. For more information about our events, please do check out our DC Talks and Training page on our website, and hopefully that will be dropped into the chat now, so you can go and have a look at that webpage. Fantastic information there, great information on our website more generally, so do go and have a look on our website. And also don't forget to subscribe as well to our newsletters for invites to webinars, our newsletter, and also events. Going to be running some fantastic in-person invite-only events in the autumn in Reading and in London. So look out for those, please. Having a break in August, chance to reflect and to pause before we're back in September, the end of September. Try and do it on the 3rd Wednesday of every month where we can. Let's get ready for October. So again, if you're not already signed up for those invites, then please do subscribe. So that's going to be an incredibly popular webinar, I know, because I've got lots of clients asking, what do we need to be doing? So let's focus on that. Also, if that wasn't enough, listen to DC Talks. We've got a podcast. It's 25-minute chat about something to do with leadership, to do with HR, to do with, people management in general. Look out for this month's podcast, which is going to be on psychological safety. A really interesting chat there, and I really hope that you enjoy that discussion. Bit of housekeeping, Stephen and I are live, but of course, as always, this is a webinar. We are not giving you legal advice. We are giving you a heads up and an overview. And if you want to find out more about what we do, how we can help you, any particular questions, then please do get in touch. Stephen and I, are here to help you. Also, if you do want to post any questions, you can do that. You can do that in the Q&A or in the chat, and we'll see if we can answer those during our session today. So without further ado, I'm going to hand over to Stephen, partner in the immigration team, to talk you through those changes which we've seen so far and what changes we've got coming. Stephen, hello and welcome.
Hi, Emma. Thank you. So yes, no, as Emma said, so I'm a partner in the immigration team, and it's been a busy year for immigration, but there's actually quite a lot is happening in the second half of the year. So probably what we'll do is we'll talk about what's happening in the future, big things happen in the autumn, and also then around winter time as well, around December. So if we go to the first slide. So what will we cover today? So over the last year, there's been a general trend towards increased compliance. So I think we've touched on this quite a lot. So Home Office audits, license revocations, the use of HMRC data now to ensure visa holders are paid correctly. And then the Home Office start looking at companies' house records as well. So a lot of what they would call desktop audits. So it's really important that you've got all your compliance and your sponsor duties all correct. Along with that, there's been in the pipeline, the Home Office has said they're going to change the right to work regime. So we now have a date, which is going to be the 1st of October. So we can now sort of plan for this. And then earned settlement, we'll touch on that quickly because that was supposed to happen in April 2026, got delayed. And now with Andy Burnham, the new Prime Minister, he's also had some suggestions on that, on the impact of that being softened, which is good news. Temporary shortage list, this will be redesigned on the 31st of December. So we have to think about what impact that will have, which sort of leads on to our fourth point in that if a job falls off the shortage list, then how do you manage the employee who doesn't meet the skill or salary requirement for a skilled worker? So they'll be our four main topics, but the first one we'll concentrate on is your right to work obligations, which will be expanded on the 1st of October. So this will come around quite quickly because we've got the summer months, then we're into September, back to school, and then all of a sudden we're in October. So I think now is definitely a time to plan for this and start to think about what do you need to do. So where we are at the moment is right to work obligations is really only for the employee-employer relation, in the sense that if someone has an employment contract, then you would do the right to work check. But what the Home Office is now looking at, so the world of work is now very diverse and there's lots of different working practices. So they're expanding the definition of who is an employer for the right to work regime. So this new expanded definition is only for the right to work regime. So you may be an employer from an employment law angle, but the Home Office under this new expanded regime could say that you're also an employer for the right to work. So we'll go into it more detail, but it's got a little bit more tricky. And obviously with this, then illegal working fines are £60,000 per employee. You've got reputational damage, so it's really important to get an idea of what these new rules are, and then how can you update and audit your policies and processes to make sure you're compliant. So if we just go to the next slide, please. So the wider definition of employer. So this is a good place to start. So at the moment, so the first bullet point there usually at the moment it's have you got a contract of employment? and then therefore you would do the right to work check. From the 1st of October, they've brought in three new categories. So it's a workers' contract, individual subcontractors, and online matching services. If we take a look at the first one, so a worker's contract, you can think of this a little bit similar to a worker within the definition of the Employment Rights Act, in the sense that they may not have an employment contract, but you're directly engaging them. They're on your premises. For all intents and purposes, you should really be responsible for the right to work. So this is probably quite a big expansion, and employers are going to have to think about, okay, we don't have an employment contract with this person, but should we, and are we responsible for their right to work? So there's a little bit of thought has to go into that sort of contingent workforce that maybe sits outside of your sort of head count. Individual subcontractor, um, again, this is something probably you'd have to sort of more think about if you were sort of supplying labor. But a really good way of thinking about this is an example. So if you had a taxi firm, so they would be the they would possibly have a just a contract with taxi drivers to work as and when they got instruction. Um, Under the current right to work regime, the taxi firm wouldn't have a contract of employment with the taxi drivers and therefore wouldn't have to do the right to work check. What the Home Office are saying is employers have to think about, are you engaging them? If it's not you doing the right to work check, who is doing it? And in this example, the taxi firm from the 1st of October would have to do right to work checks on the taxi drivers because for all intents and purposes, they are the direct employer for the right to work regime. Online matching services. So again, this is something that the Home Office are really hot on. But again, if you're introducing through an online platform, for example, if you go on to an online platform to find a cleaner or a plumber, and then you're introduced to that person, what the Home Office are saying is, well, then that online matching service should do the right to work check, because if the online matching service don't do the right to work check, no one else is going to do it. So again, it's just thinking about, um, are you the direct employer? And if if you are, you should do the right to work check. If you're not the direct employer, then who else is going to do it? And if there is a little bit of a grey area, you should probably then think about doing the right to work check, in order that the Home Office feels comfortable that someone is going to do this right to work check. The good news is that there's quite a lot of contractual arrangements that are outside of scope. So a really good example is, let's just say you're a law firm and you need to rebrand. You then get a graphic designer, and it's a business to business relationship. So the graphic designer is essentially invoicing the law firm for the work. In this example, the law firm would not have to do the right to work check on the graphic designer because essentially it's a customer relationship. So it's the provision of goods and services, and they're going to be invoiced separately. So that is some good news. So not everything is in scope, and that's why we'll go on to talk about you. There's a really big exercise here to actually look at all the people that you engage and put them in. Are you the direct employer, or are you not? And then you can scope it out. So so you won't have to do right to work checks on everyone, but you will have to think about it. Which leads quite nicely into the second big thing that's happened with the right to work check is there's a new concept, totally new concept of extended liability. And this is where the Home Office is looking at three areas. So is there a chain of contracts? So a good example would be, so let's say a business A has a contract to provide services to a third party, C, but then A enters into a contract with another company, B, who then employ the workers. So it's a supply of labor. In this regards, if the employer B, if their workers were found to have not to have the right to work, the Home Office could come back down the chain to company A, who has no relationship with the illegal worker, and say you've got extended liability. Now, there is a way to establish a defense to extended liability, and again, this comes into reviewing and auditing your contracts. So, what the Home Office say is, well, look, if company A um, is contracting with company B to provide labour, well, then in the contract there should be a written statement before the work commences. Um, there should also be substitution controls. So if company B can send substitutes, well then you have to make sure they have the right to work, and then also identity verification. So it's sort of like an imposter test. If someone turns up on the first day, is this the same person that company B did the right to work check on? So these are called the prescribed requirements. So then this sort of sits outside of sort of HR. You're probably looking at the sort of your in-house commercial lawyers to help you redraft your contracts. So quite a lot of work to do within different departments of the business. So you've got onboarding. We'll need to look at who's doing the right to work check. You've got HR, and then you've got the actual procurement and your in-house lawyers about the drafting of it. Again, there is some good news in that not everything is in scope. So purchasing worker services for your own use is outside of scope. So a really good example of this would be, let's just say you're an accountancy firm and you engage a cleaning services firm to provide cleaners, and they so in that sense, you don't have to do the right to work check on those cleaners. The right to work check would still sit with the cleaning services firm, um, because essentially that cleaning service is for your own business. So you're not then sending that labor to another business, which would be which should be in a chain of contracts. So again, lots to think about, because you do have to scope this out and get it right. If we go to the next slide, please. So again, this is directly from the Home Office guidance. So the Home Office have provided this flow chart, but I think it's a really good idea to show you how they're thinking. So how do you assess if you're in scope of extended liability? So you can see here, if you're arranging worker services for another party, so it's that arranging labor and you're sending it to a third party, that would be a yes. Online matching services, almost always a yes. Um, if there's substitutions in the contract, if that's allowed, you're probably still in scope of extended liability. If you, and again, the example that I gave, so, but if you're purchasing worker services for your own use, so the example I gave was if you're purchasing cleaning services and that is being used in your firm, then that would not be extended liability. So you can see you're going to have to map out everyone in your organization and put them in scope or out of scope. If they're in scope, then you may have to redo your contracts. So probably quite a lot to do over the summer. If we go to the next slide, there's another diagram that so again, this is a Home Office diagram. So this is taken directly from the new guidance. So just to show you what way the Home Office are thinking, they're looking to if they can't identify the direct employer, then they will look to determine, is there another employer? Is there extended liability? So if you're at the top of a chain of contracts, you got to be really careful that if you've contracted with a third party and you haven't put in that prescribed requirement, so written statements, substitution controls, and identity verification, inadvertently, even if they're not your employee, as you can see from this flow chart, you can, if you go the whole way down, so on the right hand side of the orange, you could be liable. So if the Home Office can't identify the direct employer, they'll come for the people in the chain. If your contracts aren't right, you can be liable to a civil penalty, which as we touched on, can be up to £60,000 per employee. So it can get very expensive very quickly. So it's really important to scope things out. Are you the direct employer? if you're not the direct employer, can you still get a fine for extended liability? Um, so this is a good way of looking at. You can see what the Home Office are thinking. They're looking for ways to for someone to be responsible for the right to work check. So if we go to the next slide. So again, we've covered quite a lot of this, but I think if you wanted sort of a quick to-do list, so you need to inform leadership that changes are being rolled out, and you'll need to budget for this. Then the first thing to do is map out all your workers that you employ or you engage, and you want to, under the new definition, you want to put them into, are you their direct employer for the right to work check, or are you not? Once you've defined that, then you also need to consider your contracts. So you want to then say, okay, I'm not the direct employer, but can I be liable for the extended liability? And again, at that point, you need to get your in-house lawyers, your contract lawyers, to help you then to redraft your warranties and indemnities. Operationally, again, this probably similar to informing leadership. Um, you would need to look at who's going to be responsible for this. So at the moment, it's fairly straightforward. Are they an employee? Do they have contract of employment? And then someone does the right to work check. With all these new things, there needs to be some policies to work out who's responsible for what. So who's going to scope it? Who's going to look at the contracts? Who's going to draft the contracts? So there's quite a lot of prep work before you actually work out your obligations. What can really help with this is tech solutions. So there's quite a lot of providers who will there's apps and there's companies that can do these checks online, and then there's also facial recognition. So if you've got a lot of workers that you think you may have extended liability for, you may want to streamline this, and you may want to employ some tech into your onboarding. And lastly, as Emma always says, you'll want to upskill your HR teams. So this is quite a lot of work, and with the increased compliance scrutiny from the Home Office, then they could also audit you as well. So I think yeah, lots to do in this. We will run another webinar just on this topic. Because the clarity only really came through last week on this. But for now, definitely inform leadership, map out who your workers are, and then try and scope out who's in the new rules and who's not. So yeah, so lots to cover there, and we'll touch on that all again. But another big trend, and this has been going on since 2025, and we've covered earned settlement quite a lot. But for those who don't know what this is, essentially the government has said that in order to get settlement in the UK, so indefinite leave to remain, they're going to move the qualifying period from 5 years to 10 years. And also they're looking for people to contribute to the community. Also looking at high earners. So if you're a high earner, you may get to settlement after 3. If you're earning over 50,270, you could get to settlement still at 5. So quite a controversial new rule, a new regime. And a lot of visa holders, a lot of employees had it in their mind that they were set at getting settlement at 5 years. So moving that to 10 is a wholesale change. Some good news is that first of all, it's been delayed, so there's probably a lot more people who are getting to the 5 years before the rules change. But also, Andy Burnham's new leadership team and Andy Burnham himself has suggested that there will be a slight softening of the rules. So it was said that it was going to be retrospective, which seems quite unfair. So you may find that it's not retro. So if you're already in the UK on a skilled worker visa, you may find that you will still be able to settle at 5, although all of these rules still have to be set out. So we're probably looking at the autumn, possibly, or even into 2027 before this all comes to place. But if we go to the next slide, there's a few things that you can do at the moment. So undertake an analysis of who can apply now. But if you can apply before the new rules come in, then you'll still get it at 5. So that's really important. Also, you might have to budget for increased costs. So if you thought someone was possibly getting a settlement at 5 years and it's going to be 10 years, you're going to have to sponsor them for another further 5 years. So that's going to be more costs to the business. Also, you may want to audit your salary banding so that if you do want to bump up anyone's salary within the moderation year, in order to get them to those marks. So at 50,270, they're saying you'll qualify at 5. At 125,140, at the moment, they're saying you'll qualify at 3. So you may want to think about your salary bandings to make sure that you can maybe put people in those brackets. Reassure and communicate and upskill your HR teams is normal, similar to most of these big sort of changes. And if we go to the next slide, so thirdly, another big change that's going to happen, and again we've got the date for this, so again you can plan for this. So on the 31st of December, the temporary shortage list will be redesigned. So the temporary shortage list essentially has a lot of rules that are at RQF level 3. Now in July last year, the new rule was that you couldn't sponsor someone under an RQF level 3 job, so anything under RQF level 6, unless it's on the temporary shortage list. So this temporary shortage list essentially has acted as a transitional arrangement for the change last year. So you'll find you may have lots of people that are sponsored under this temporary shortage list, or you may have graduates who you want to be that may want to be go onto this list and be sponsored as a skilled worker. The main impact of this redesign will probably be on your graduate recruitment and also people at the medium skilled jobs. So our advice would be that obviously you've got the big change in the 1st of October for the right to work, but shortly after that, once you've organised that, you should be thinking who's coming up for expiry in January, February, March, because you may want to bring their extension forward so that you can use this temporary shortage list. Or if you've got some grad visa holders and you want to bring them into the skilled worker route, again, you may want to do that earlier, because at the moment we're unsure what the temporary shortage list will look like. So there will still be rules that are on that will be on a shortage list, but they will most likely not be as many. So you may find there's some jobs that you just can't sponsor after they fall off this list. So you got to think about that for the 31st of December. And then, oh sorry, if I just go back, sorry, one more, sorry. Yes, and lastly, so linked very closely to this, if the worst happens and you say a rule falls off the temporary shortage list, we get quite a lot of questions. So like, how do you manage an employee if they don't meet the salary list or don't meet the skill list? Some things that you can do. So you're going to have to look for possibly an alternative vacancy that's suitable and the person's interested in. Is promotion on the card? So can you promote someone to get them onto a role that can be sponsorable? Can you increase salary? Again, you have to be very careful to retain the integrity of your pay bands, and also you don't want to be accused of any indirect discrimination to your UK workforce. So you have to be careful and seek employment advice on increasing salary. And then again, you'd have to speak to an employment lawyer about this, but you would also have to consider dismissal, because if you can't sponsor a role, then you'd have to sort of objectively explain why you can't increase the salary or provide an alternative role, and you'd need to get employment advice then. So lots happening at the end of the year. So essentially from autumn, winter, there's quite a lot of dates that you need to think about. I've gone through that very quickly. So if there's any, I don't know, Emma, if there's any questions, should we do it at the end or
We have had
anything?
one. We have had one question, which I think we'll do with now. But just on that point about, somebody might not be able to be sponsored what do we do with them? I think always the advice, and again, with the employment lawyer's hat on, is that sometimes immigration law can be quite blunt. They don't have the right to work. Employment law is a bit more nuanced in terms of, looking about fairness, looking at fair procedures, looking about, contractual rights, fairness rights, statutory rights. So I think the point is never assume that just because somebody doesn't have the right to work, it doesn't mean that we can, automatically end employment. The answer is sometimes, a bit more nuanced. So yeah, absolutely on that. So we did have a question, Stephen, and again, I'm putting you on the spot, so apologies. And if it's a more detailed question, then we can go back afterwards. Was around multi-factor authentication for sponsorship management systems. Just a question was what that is. And again, I'm happy to, that might be one that we need to go back on, because I appreciate it might not be a kind of it's this. It might be lots of different things. So I will leave that to your discretion.
Yeah, I think I know what the question. So on the sponsor management system at the moment, you can log into it if you have your username and password. Similar to
Mm,
other things. I think what the Home Office are going to do is they're going to have to send a code to your mobile. Essentially, you're going to have your mobile number registered, and then they'll send a code to your mobile,
mm.
and then you put that code in. So I think what the Home Office are doing is the sponsor license system, the sponsor management system. They're just making sure that the person who is logging in is actually the person. Is the person is the correct person. So it's just
Okay.
essentially it's just a double check.
Sure. So similar to other systems you might log into. Of
Yeah.
course, with multifactorial authentication brings up lots of issues. Whose mobile phone is it? What happens if somebody is away on holiday? So again, there might be some logistical stuff there. Um, just had another question in. So again, this might be one that we need to take offline, but can you just clarify that if someone is heading towards the 5-year anniversary in 2027 and they fall under the £50,000 bracket, they now have to wait for 10 years, i.e., is there any transition?
So yeah. So if the new rules haven't come in place, then obviously they're fine.
Yeah.
If if the let's say the new rules do come, if the new rules have come into place at the moment, um, they have indicated they would be retrospective. So that person would be really unfortunate. So they may have to do another 5 years. So yes, but the indication from the new Andy Burnham leadership is that they won't be retrospective. So hopefully for that person, the retrospective element of this gets removed, and then they would still get their indefinite leave to remain at 5 years. But if it is going to be retrospective, then they could be very unlucky, and essentially the new rules would kick in, and they would have to do 10 rather than 5. So you can see how unfair that is. So you can see how most people, I think most fair-minded people are hoping that it's not going to be retrospective because
Mm.
it just doesn't seem very fair.
And then, of course, from an employer perspective, you've got the do we have to sponsor for another 5 years? What's the likely cost of that going to be? So actually, the uncertainty here is terrible for individuals, but also not so great for employers as well. So let's sort of hope we get some clarity on that. So just a reminder, if you sign up, when you log on to the subscription page, you'll also get information about how you can sign up to our immigration updates as well. So I would urge you to do that as well. Yeah, I mean the right to work checks, I can see that causing all sorts of bother, and it's really interesting that point about the substitution clause, because we often see those in contractor agreements when we are engaging with a consultant, which is you may send somebody who is suitable. And again, I can, see some issues there around how are they drafted? Should we be including substitution clauses? That's going to be a very interesting debate to have, and it will probably depend on who the person is. So lots to do and lots going on. And let's obviously just kind of add to that, shall we, with some employment issues as well. Look, we've been talking about these issues for a long time, and those of you who've regularly joined the webinars will know that we've been talking a lot about, the April changes and what they mean. And obviously, we've been looking ahead around what's going to happen coming up. If you are, just a kind of a recap in terms of where we are with the Employment Rights Act, obviously came into force in December. We had a few sort of issues there around trade union bits and bobs that came in December, but really the bulk of the changes started in April of this year, primarily around kind of family leave and sickness absence are related to obviously sick pay. So more kind of, internal policies and processes and making sure that managers are aware of, paternity leave being a day one right, parental leave, that unpaid right, again, moving to be a day one right. The introduction there of that new partner bereavement leave as well that was introduced again from April of this year. So it was very much, kind of getting our ducks in a row. Have we thought about our policies and our processes? The introduction of SSP as a day one entitlement, again, from the first day of sickness absence, so the removal of the waiting days as well as the lower earnings limit, albeit with that slight, looking at, is it 80% of earnings there? So again, looking at that has made a real impact, I think, on businesses that do only pay SSP. So again, it's an opportunity there to really think about your sickness absence processes. How good are they? And be honest. Have we got managers who are doing their return to work interviews? Are they doing their checking up on self certificates? So, lots of things that we can do in practice. And I think, again, as Stephen said, audit. So have we put to the business said, look, this is the difference in cost between, waiting days and to having those waiting days removed, as well as more workers being entitled there to receive SSP. So I think, let's look at the impact and then obviously look at how we can, improve the way that we do things such that we support individuals who need our support, of course, but also we have those systems and checks in place to really show us when, as a business, we need to step in to address if we've got absence issues. Redundancy, we saw the protective award claim. Again, that failure to inform and consult, where you've got those collective redundancies, those larger scale redundancies, that increased to 180 days of actual pay. So again, a huge shift and a huge risk. Remembering as well that, we can't contract out of those claims in a settlement agreement. So, some real issues for businesses, really focusing now on process. And also, as we move forward into next year, we're going to see different triggers. We don't know what they're going to be yet, whether it's going to be a fixed amount or a percentage, but we are going to see more smaller scale redundancies being caught by these extended definitions. So we're going to see more redundancies, whereas before we would just go, it's less than 20, we'll individually consult. We're going to see those being picked up. So again, we've got the change now in April, but we're going to have, more of a change happening in 2027. So we need to start thinking about, how we're going to manage redundancies. Maybe we need to think about, workforce planning now. And certainly working with a number of clients in terms of, well, let's look at where we are, where do we need to get to, and really strategically focusing on the new rules and how they're likely to affect, and actually, can we be making decisions now? Whistleblowing as well from April became that potentially there a protected disclosure under whistleblowing laws. So again, looking at whistleblowing policies, upskilling our whistleblowing officers and champions around, being aware that complaints about sexual harassment, again, where you've got more of a kind of an institutional behavior, more thinking about collective issues around sexual harassment, again, they can be raised as a whistleblowing. And remember as well, whistleblowing, unlimited compensation, again, automatic unfair dismissal, and obviously workers can bring those claims, and you've got that detriment claim as well. And we'll come on to talk about some of the changes that we've got coming in October around about sexual harassment and also third party liability as well. And the Fair Work Agency, this came into being from April, focusing on national minimum wage, focusing on holiday pay, and also we saw that new obligation on employers to record statutory holiday, what's been taken, what's been paid, again, keeping those holiday records for 6 years. So, lots of changes around enforcement, and particularly, keep an eye on the Fair Work Agency. What should we be doing over the summer? Well, Stephen's given us some real fantastic heads up there in terms of, getting things and starting to think about who's working for us, how they're working for us. Are we potentially going to be caught by the right to work checks, either directly or by this extended liability? So we need to start thinking about that. But we also need to start thinking about these changes as well that are coming in. 1st of September, those of you who work in regulated industries, the FCA's new rules with regard to non-financial misconduct. So again, we need to think about what impact that's going to have in terms of our strategy, in terms of who that impacts within the organization. Do we need to think about specific tailored training for those individuals who are in that senior management role, who are classed as being certified, as well as wider employee populations? So regulatory rules as well that we need to focus on. What does that mean for policies, for processes, and also how can we feed that into our risk assessments? As we know, that preventative duty that sits on top of the Equality Act, again, that positive, proactive, mandatory duty. What reasonable steps have you taken as an employer to prevent sexual harassment in the workplace? That shift from this won't happen here to this could happen here, and that bar is being raised from reasonable steps to all reasonable steps, not only with regards to sexual harassment, but third-party sexual harassment there. But also, we've got the raising of the liability bar with regards to third-party harassment, which again includes sexual harassment. So comments by customers, comments by clients, with regards to comments regards to protective characteristics. Okay, so harassment related to protected characteristics as well as unwanted conduct of a sexual nature. Again, have we taken those preventative steps, those all reasonable steps as an organisation? And be critical and ask yourself, if somebody were to raise a claim, okay, could we really say that we'd taken those all reasonable steps? And I'm working with lots of businesses, looking at their risk assessments, looking at how the FCA rules impact upon them, running bespoke targeted training. That's what we're really focusing on. You've got to look at your individual risk assessment. One size does not fit all. Who are you? What do you do? What sector do you operate in? Where are your key risks? How are your people working? Who do they have interactions with? Where's the power imbalance? Have we created that speak up culture? Do we have different reporting routes? Have we got whistleblowing routes? Do we monitor the effectiveness of those routes? Okay, these are all things that we're talking to businesses about. So if you want to find out more, then please do get in touch as to how we can help you. If that wasn't enough, the extension of the employment tribunal limit from 3 months to 6 months from the 1st of October. Again, a huge impact. We know how backed up the employment tribunal is at the moment. We saw the extension of the early conciliation period to 12 weeks from December. Again, this burden on the tribunals and also thinking about how long it's going to take potentially before we even find out if somebody's brought a tribunal claim. Documents, retention periods, data protection policies, all of that good stuff. Trade union rights of access. For many of us, managing trade union relationships, having any kind of contact at all with trade unions has been slightly alien. We're going to have to remember that again from October, unions are going to be able to request rights of access to your workplaces. Watch the space on that. We've got some consultation, so we are awaiting the sort of final details on that. But again, focusing on trade unions because I think it's going to be a real area where potentially employers are going to get it wrong and the costs could be potentially quite eye-watering. We know the 1st of January, we've got it etched in our brains. Remembering, of course, that this qualifying period is going to reduce to 6 months, but there are lots of wrinkles with that. And it does not mean that, it's okay, we're at 6 months, less than 6 months, we're fine. So we need to really be focusing on and auditing, lengths of service. Yeah, we don't not they're on probation, length of service. So again, I'm sensing that there's a few employers that say, it's okay, Emma, we've got a 6-month probation period. They are not the same things. So again, we need to really focus on what this risk means in practice and where are those wrinkles and how employers are going to be caught out because they're going to leave it to the last minute. So again, lots of work to be done on that. Thinking about the compensation cap being removed, is now the time to start thinking about those problem hires, maybe people who have got less than 2 years service now, maybe people who've got more than 2 years service now, but what we want to do is rely on that unfair dismissal cap that we are clinging on to until obviously the 1st of January. So again, really focus on, are there things we could be doing now? And then explain to the business the cost, come next year potentially if we don't. And that's going to be the key message. Fire and rehire as well. Again, that making it more difficult to change contracts of employment. Do we need to think about contracts of employment now? My love of a contract of employment. We don't use them effectively enough, but is there an opportunity to really kind of look at our contracts? When were they last updated? Are there things that need to be changed now when we think about the difficulty potentially next year? So what can we be doing now? And that really brings me to my new little 3-word mantra. Those of you who've listened to me before, I've done some training, I love a 3-word mantra. Plan, train, and audit. Stephen, from your world, plan, train, and audit, what does that mean?
Yeah, absolutely. So it's again, we've got the dates that we know that the rules are going to change. So yes, you need to plan for the 1st of October, plan for the 31st of December. But yeah, training's really important because there's so many people within the organization that are involved in these changes. So you've got, onboarding, HR, as I was saying, like then you've got your contract lawyers, you've got leadership, and then the audit is that once you've got this all scoped out, you'll need to audit all your policies and procedures and make sure they're all correct and up to date. So yes, if you go for those 3 things, it's a good start.
Absolutely. And, from my perspective, planning for the changes, we know roughly the kind of months we're looking at. All right, we haven't got exact dates, so we don't know exactly when things are going to come in, to that level of detail. But we know that things are happening and things are changing. And I don't think that, the new government will change anything. We haven't heard any murmurings in terms of the Employment Rights Act. It's very much, full steam ahead. So plan, plan, plan. Also, who is this going to impact within your organization? What do we need to do now? Mapping what you need to do, policies, processes, contracts, training, sexual harassment training, third-party harassment risk training, bespoke training that really looks at your specific risk profile that needs to be, tailored to you and refreshed. It really is, so important that we engage our managers and our boards with these changes. I'm sensing a lot of my HR contacts are feeling a little bit isolated here. But again, you've got to spread the word within your organization. Again, happy to come and run some sessions as well to kind of really spread the good news, as we say. An audit as well. Who's working for you? How are they working? In what capacity? How long have they worked for you for? Are we creeping to the 2 years? Do we need to act now? Do we wait? Again, all of these things are really important, and particularly when we think about 0 and low hours workers as well. Who's working for us in what capacity? There's lots to be done, but I think we've got a real opportunity here to really get a grip of, firstly, who have we got within the organization, thinking about, structures and maybe thinking about, do we need to make changes? And then having the opportunity again to plan and really work through those changes and take those opportunities where they are. So yes, there's lots going on. But again, I think we need to focus on where are those opportunities within the organization to make a change, whether that's, raising your HR voice within the senior leadership team, or also whether it's ensuring that you've got that really good stuff that you're doing, making sure that it's disseminated down as well, and that everybody understands the expectations and understands what those rules are. And again, I can't stress that sexual harassment and third party risk enough, because I think it is going to become a real issue for employers. So lots to do. Stay in touch, please. We will see you in September for our September webinar. But again, we're around, so do get in touch if we can help. There are lots of things that we're doing with supporting clients, whether that be with policies and processes, training, workforce planning, strategic support, as well as litigation as well. So, please do reach out if we can help. So thank you very much. Can I just take the opportunity to wish you all a fantastic summer with lots of post-it notes and planning and diaries open and flow charts on the wall. But we're here to help, and I look forward to seeing you all in September. And Stephen, as ever, thank you so much for joining me.
Great. Thanks, Emma.